Okay, so here we are. Nandito na tayo sa different forms of contracts. So before we proceed to the main topic, recall muna tayo. So there was a classification of contracts na binanggit natin dun sa first video natin tungkol sa contracts, which is according to perfection. Okay? And then we discussed these three. We have consensual contracts, which is generally the classification of any contract in general, di ba? Kasi pag consensual, COC lang siya. Consent, object, and the cause ang kailangan lang dyan. Okay, number 2 are real contracts, which in addition to the COC, kailangan niya ng delivery. And lastly, which is our topic for today, are formal or solemn contracts, which, aside from the COC or the consent, object, and cause, kailangan niya ng certain formality in order to be valid. Okay? So, those are formal contracts. However, okay, pag sinabi natin kasing forms of contracts in general, we don't necessarily always mean about validity, okay? Or it doesn't necessarily refer to validity. Kasi ito nga, why contracts need to be in certain forms, or bakit ba kailangan na nasa isang certain form sila? Okay, gaya nga nung nabanggit natin, yung mga contracts na classify dito, number 3, or contracts that are formal, ibig sabihin, kapag hindi nasunod yung formality, magiging invalid contract sila or void contract sila. Okay? So that is their classification, number 3. However, there are certain contracts wherein kailangan nila ng certain form pero hindi po siya for the purpose of validity. Ibig sabihin, kahit na hindi masunod yung requirement na yun, hindi siya essential requirement. Okay, so basically, hindi po yun formal contract. Okay, hindi po sila mag-falls sa number 3. Hindi po sila formal contract. Kasi ang definition po natin sa formal contract is, in addition to the COC, meron pa silang essential requisite, which is the, the formality required by law. Okay, so ayun. Aside from validity, what are the other purposes kung bakit kailangan ng formality? Okay? So, we have here, okay? Number 1, 2, and 3. We have 3 reasons actually. So, number 1, yung validity, yung nabanggit natin. So, ibig sabihin, yung mga contracts na hindi sumunod sa proper formality under this one, number 1, they will be considered void contracts or non-existent contracts. Number 2, okay? Yung mga contracts na hindi susunod, okay, sa kanilang formality, at yung formality na yon ay required for enforceability, okay, hindi nila sinunod, ang mangyayari ay hindi sila magiging void, pero magiging unenforceable contracts lang. So, this will be discussed on the upcoming videos, okay? So, may malaking pagkakaiba po ang unenforceable at void contracts, okay? So, i-differentiate natin yan later on sa mga susunod nating videos, okay? Pero for now, okay, isipin nyo muna, basta iba ang void contract from an enforceable contract. And lastly, number 3, okay, some certain formalities are required for the convenience of the party. So, anong ibig sabihin yan? Kahit na hindi masunod, okay, yung formality na binabanggit natin yun, anong mangyayari? Valid and enforceable pa rin yung contract. However, in practice kasi, mahirap patunayan ng isang kontrata lalo na kung ito ay oral lang or verbal, di ba? Kung walang kasulatan. Okay? So may generally kasi ang contracts hindi naman kailangan in writing. Okay? Maraming contracts diyan na hindi kailangan in writing pero magiging valid and enforceable pa rin sila. Yun nga lang, although valid and enforceable sila, pagdating natin sa korte, hindi natin basta-basta mapapatunayan yun kung ganun lang, di ba? Kung pure verbal lang yung basis natin dun sa contract. So, medyo, yun nga, mahihirapan tayong makaklaim ng damages if ever. Okay? So, yun nga, number 3, for the purpose of convenience of the party. So, kailangan nasa certain form sila. Okay? So, magbibigay tayo ng example sa bawat reasons ng formalities. Okay? So, unahin muna natin yung mga contracts which are okay, needed to be in certain forms in order to be valid. So we have 7 examples. So ayan, tinable natin sila. So inuulit ko, ito po yung mga contracts, okay, that needs to be in a certain form in order to be valid. Kasi kung hindi sila sumunod sa tamang formality, anong mangyayari? Magiging void contract sila. So for example, number 1, donation of personal property whose value exceeds 500. Actually, this is 5,000, okay? So, mukhang na-typo na naman tayo. So, donation of personal property whose value exceeds 5,000, it must be in writing. Kasi kung hindi siya nasunod in writing, ano mangyayari? Yung donation na yan ay void. Okay ba? And take note of the word or of the object of the contract which is a personal property. Okay? Personal property na ang value ng personal property na yon ay exceeding 5,000. So, it must be in writing. Okay? Next, when you donate real property regardless of amount, it must be in public instrument. So actually, when we refer to this formality dito, specifically sa donation, we refer to both the initiation of the contract and the acceptance of the contract. Ibig sabihin, yung initiation and acceptance kasi pwedeng nasa iisang papel lang or pwede ring nasa separate paper. Okay? So, for the first case, kailangan na yung initiation in writing as well as the acceptance. Dapat in writing yung acceptance. Also, with the donation of real property. Okay? The initiation of the donation must be in public instrument. Pag sinabi natin public instrument kasi, meron tayong private instrument na papel, di ba? In writing, tapos ipapanotaryo natin. Okay? And then also, with the acceptance. Kailangan yung acceptance din ay in public instrument. Okay? So, kung hindi masunod yung mga yun, magiging void yung yung donation po natin. Okay? So, those are the first two na example natin. Next. So, nabanggit natin last time na partnership are consensual contract. However, there are exemptions. Okay? So, ano yung exemption natin? Ito, partnership where immovables are contributed. Every time na meron tayong i-contribute na, let's say, land, building, or any other immovable properties sa isang partnership, kailangan the partnership contract must be in public instrument, okay, together with the inventory of immovables contributed. Kasi kung hindi yan nasunod, void po yung contract of partnership natin. Okay ba? Okay. So, next, sale of a piece of land or interest therein through an agent. Okay. So, in order for the contract of sale of the piece of land to be valid, the contract of agency must be in writing. However, the contract of agency need not to be in writing to be valid. Okay? Ang mai-invalidate lang po dito is yung sale, yung contract of sale kapag hindi in writing yung contract of agency. Okay? Pero yung contract of agency, okay lang. Okay? So, ayan. Next, we have anti-crisis. So, yung anti-crisis, we will discuss it on future law subjects, okay? Pero, yung anti-crisis po kasi, isa po siyang contract that needs to be in writing. Okay? So, kung gusto nyo basahin kung ano yan, refer to Article 2134, okay, of the Civil Code. Next, chattel mortgage. Okay? So, chattel mortgages must be registered in order to be valid. Okay? So, kung hindi siya na-register, void po yung chattel mortgage. Okay? Tandaan nyo, ang real mortgage pero, consensual contract po yun. Hindi po yun kailangan na ma-register or in writing or whatsoever form. So, consensual lang yun, meaning, kailangan niya lang yung COC, di ba? Consent, object, and cause in order to be valid. Okay, and last, agreements regarding payment of interest in a contract of loan. So, ayan, okay, magiging valid yung agreement natin with regards to the interest kapag yung contract of loan ay nasa, okay, in writing. Okay? At yung contract of loan na yun, binanggit niya doon yung interest, syempre. Okay? So, it must be in writing. Otherwise, walang interest na masisingil. Okay? Hindi ka pwedeng maningil ng interest kung walang kasulatan in writing. So, tatandaan nyo yan. Okay? So, next, let's proceed to, okay, contracts that need to be in certain forms for their enforceability naman. Okay, so sabi natin kanina, kapag hindi nasunod yung tamang form, okay, doon sa mga ganitong klaseng contract is magiging unenforceable contract sila. So, ito, actually, itong mga to, yung mga contract na ito ay makikita sa Article 1403, Paragraph 2. So, bali meron tayong 6 dito. Okay? Itong mga to, kapag hindi sila in writing, okay, inulit ko, itong 1, 2, 3, 4, 5, 6 na ito, kapag itong mga to hindi sila in writing, hindi sila enforceable. Magiging unenforceable contract sila. Okay? Pero hindi sila void. Okay? So, tatandaan nyo po yan. Hindi sila void. Unenforceable sila, okay? Pero hindi sila void. Pag unenforceable, actually, valid contract pa rin yun. Yun nga lang, hindi mo pwedeng ma-enforce kasi unenforceable nga. Okay? Pero ang void contract, invalid yan. Okay? So, anong pagkakaiba? Kung invalid ang isang contract, malamang hindi siya ma-enforce. Anong pagkakaiba? So, anong pagkakaiba ng unenforceable at void? So sa mga future videos, abangan natin. Okay? Okay? Itong mga to, number 1 to 6, hindi natin masyadong i-discuss to today. Okay? Because this is reserved dun sa chapter ng unenforceable contracts. I-explain po natin kung ano ba tong klaseng contracts tong mga to. Okay? Pero for now, basahin nyo tong mga to. Kung itong mga contract hindi sila in writing, sila ay unenforceable. Okay? So, tatandaan nyo po yun. Okay? So, next, let's go to the last one. Okay? So, contracts that needs to be in certain forms for convenience of the parties. Okay? So, itong mga contracts na mababasa nyo dito, kung hindi niya po nasunod yung babanggitin kong formality, hindi po ibig sabihin magiging void siya or magiging unenforceable siya. Perfectly valid pa rin siya. Yun nga lang, okay? Ito kasi yung mga usual instances or usual contracts wherein, di ba? In terms of, parang kumbaga laging pinag-aawayan sa korte, okay? Yun nga, mahirap patunayan kapag walang kasulatan, okay? So, itong mga contracts na to, for the convenience of the parties must be in public instrument, okay? So, this is based on Article 1358. Okay, inuulit ko, these contracts na mababasa nyo dito must be in public instrument for the convenience of the parties. So, kung hindi man yun masunod, okay lang. Okay, valid pa rin yung contract. Okay, however, itong mga contracts na to, kapag ang isa sa mga party, kinumpel niya yung isang party na dapat yung kontrata natin in public instrument, kailangan mag-comply yung kabilang party. Okay, so meron silang karapatan na ganun. So that is based on Article 1357 naman. Okay? So any party, okay, which are involved in these types of contracts, yung mga nalay down natin dito, pwede niyang i-compel yung kabilang party to observe the proper formality, which is in this case, itong mga contracts na to ay in public instrument. Okay, so pwede nilang makumpel ang isa't isa. Okay ba? Pero inuulit ko, kung hindi man nila masunod na in public instrument, ano mangyayari? Okay, ang mangyayari is valid pa rin yung contract natin. It doesn't affect its validity. Okay? So, ano yung mga to? Number 1, acts and contracts which have for their object the creation, transmission, modification, or extinguishment of real rights over immovable properties. Okay? So, for example, real mortgages. Okay? So, real mortgages, okay, sabi natin, consensual lang ang real mortgage. Okay ba? So, medyo malalaking value ang involved sa mga real mortgages kasi 'di ba pag real mortgages ang object nun ay isang real property or immovable property which is nabanggit nga dito, 'di ba? Okay? So ayan, mahirap naman sigurong patunayan sa korte kung sakaling nagloko yung kabilang party kung verbal lang yung tawag dito, yung contract natin regarding the real mortgage. Okay? So ayan. So, number 1, yun nga, ang example natin sa number 1 kapag meron tayong real mortgage, okay? So, may nabanggit pala bali dito sa number 1 na sales of real property or of an interest therein are governed by Articles 1403. So, actually, this is yung Article 1403. Ito yung nabanggit natin kanina which is, yung mga contracts that needs to be in certain form for their enforceability. Okay? So, matatakal natin ito under unenforceable contracts. Okay? Itong sinasabi niya dito, yung sales of real property, blah, blah, blah. Okay? So, number 2, the cession, repudiation, or renunciation of hereditary rights or of those of conjugal partnership of gain. So, example na lang, kung i-renounce mo yung share sa isang, let's say, sa mana, di ba? Kumbaga, masyado kang mabait, kaya ang ginawa mo is ni-renounce mo yung share mo, hindi mo na lang kukunin, pinaubaya mo na sa mga kapatid mo, di ba? So, ayan. Yung ganyang klaseng kontrata, yung renunciation, actually, okay lang na verbal, valid pa rin yung kontratang ganyan. Pero, okay, yun nga, according to Article 1358, parang kumbaga, kinukonvince niya na, lagyan natin sa public instrument para kapag sakaling nagkaroon ng problema, okay, pagdating sa korte, okay, magiging convenient para sa atin, di ba? Madali nating maputunayan na yun nga, okay? So, number 3, the power to administer property or any other power which has for its object or an act appearing in which should be appear in public document or should prejudice a third person. So for example, meron kang properties, meron kang business, sabihin na natin, yung business mo it involves certain immovable properties and other personal properties, 'di ba? So yung pag ipapaubaya mo sa iba yung pag-administer nung business na yon, so okay lang na okay. So dapat parang kumbaga verbal lang, okay lang. So valid pa rin 'yun. Pero okay? Pero, kung sakaling nagkaroon ng problema, mahirap patunayan na parang kumbaga yung ganung klaseng right binigay mo nga talaga sa kanya. Okay? So, ayun. For the sake of convenience, kailangan in public instrument yung mga ganung klaseng kasunduan. Okay? And lastly, the cession or actions or rights proceeding from an act appearing in public. Okay? So, number 4, the cession of actions or rights proceeding from an act appearing in public instrument or document, okay? So, dito sa number 4, ang sinasabi lang dito actually is for example, number 2, sabi mo hindi mo na kukunin yung mana mo, pero nagbagong isip mo, so gusto mong baguhin yung earlier decision na ginawa mo. So, in this case, okay, kailangan yung gagawin mong session of your action, kailangan in public instrument din ulit. Okay? For the convenience. So, inuulit ko, itong 1 to 4 na ito, although hindi masusunod yung tamang formality na sinasabi ni Article 1358, hindi niya maaapektuhan yung validity ng contract which is produced by this different transaction number 1, 2, 3, 4. Okay, so valid pa rin yung contract. However, yun nga, okay, sinasabi natin, kapag hindi sunundan, pagdating sa korte, medyo mahirap patunayan. And also, according to Article 1357, both parties may compel each other to observe the proper form. So, under convenience, yun nga, public instrument tong 1, 2, 3, 4. Okay? And meron pang nabanggit dito, all other contracts which the amount involves 500 pesos. Okay? So, mag-isip nga tayo ng isang kontrata na hindi nabanggit from the previous slides which refer to validity, to enforceability, at hindi rin nabanggit dito sa 1, 2, 3, 4. So, mag-isip tayo. Okay. So, ito, contract of loan. Pero walang interest this time. Kasi nabanggit yung pag may interest sa sa validity, di ba? Kapag may interest, kailangan in writing yung loan para maging valid yung interest. Okay? So, this time, contract of loan, which is more than 500. So, nagpahiram ka ng pera pero walang interest. Okay? So, those kinds of transaction, kailangan in public instrument lang daw sila. Pero, or in private instrument lang, okay lang. So, itong 1, 2, 3, 4, public instrument. Pero, yung all other contracts which involve amounts, okay? Amount exceeds 500 pesos, di ba? Kapag more than 500 pesos, kailangan kahit in private lang sana. So, kahit in writing lang, kahit hindi mo na notaryo, okay lang. Okay? Pero inuulit ko, kahit na hindi mo masunod, itong sinasabi ulit ng last paragraph na to, valid pa rin yung kontrata mo, yung contract of loan mo, kahit more than 500 pesos yan. Okay, walang interest. Okay lang, valid pa rin yun. Okay, yun nga lang, pagdating sa korte, inuulit ko, mahirap patunayan na mayroong ngang utang. Okay, lalo na kung magpaperang ka ng 100,000, grabe naman yan kung hindi ka hindi mo papipirmahin sa isang kasulatan kasi 'di ba pwedeng kang takbuhan, malaki-laking halaga yung 100,000 if ever, okay? So ayan. Okay? Pero meron siyang ulit binanggit dito, but sales of goods, chattels, or things which in action are covered by Articles 1403, number 2, and okay, so basically this is yung mga under an enforceable contract. So 1403, 1405, makikita po natin yan sa chapter ng unenforceable contracts, specifically chapter 8 nitong contracts, okay? So meron tayong separate video dyan in the future, okay ba? Okay, so sana naintindihan nyo yung mga different reasons kung bakit kailangan ng formalities ng mga certain contracts or kailangan ng forms ng mga certain contracts na ito. Okay, hindi lahat for the validity only. May mga mangilan-ngilan kailangan for enforceability at may mga mangilan-ngilan kailangan nila for the convenience of the parties. Okay, so that's it for today. Nandito na tayo ngayon sa topic ng Reformation of Contracts. So, what is Reformation of Contracts? So, by the way, this is another short video dahil short lang yung chapter na ito, as well as the next video which is Interpretation of Contracts. So, ayan. After nun, doon na tayo mapupunta sa mga different defective contracts. So, doon mas magiging detailed ulit at siguro magiging mahaba-haba ang mga susunod nating videos doon. Okay? So, ayan. Reformation of contract. It is a remedy whereby a written instrument to the contract is amended to conform to the true intentions of the parties. Okay? So, nandito, yung word na amended, babaguhin natin yung written instrument that represent the contract. So, by the way, sabi natin last time, di ba? Ang kontrata, hindi necessarily written. Kung sakaling meron man tayong written contract, yung kasulatan na yun, hindi yun yung mismong kontrata. Yun lang yung written instrument na nagre-represent doon sa kontrata. Okay? So, ayan, babaguhin natin yung written instrument if hindi ito tumutugma, okay, doon sa talagang or totoong napag-usapan natin or totoong napagmitan ng minds natin, di ba? So, yun yung sa consent, meeting of minds. Okay? So, yun yung reformation. Okay? Ang nire-reform, hindi po contracts actually. Ang nire-reform talaga is yung written instrument. Okay, that represents the contract. So, it's not the contract itself being reformed. It's the instrument that represents the contract. Tatandaan nyo po yan. Okay? So, what are the requisites of the reformation of contract? So, we have 3. This is based on Article 1359, paragraph 1. So, number 1, there must be a valid contract. Okay? So, meaning to say, meron tayong COC tulad nung nabanggit natin last time, di ba? So, that is consent, object, and the cause. So, sana meron yung tatlong essential requisites na yan para maging valid contract siya. Okay? Pero may mga certain contracts that require additional essential elements such as real contracts na kailangan ng delivery and formal contracts na kailangan ng specific, okay, formality. Okay? So, number 2, the written instrument, yung kasulatan that represents the contract does not conform to the true intentions of the parties. Okay? So, hindi siya tumutugma. Okay? May napag-usapan tayo, pero nung nakasulat na sa papel, hindi siya parehas. So, anong masusunod? Siyempre, kung ano yung napag-usapan talaga natin. Kung ano yung nagkaroon ng meeting of minds tayo. Okay? Kung ano yung idea na nagkaroon tayo ng meeting of minds. Hindi yung kung ano yung nakasulat dahil formality lang yon. Kung matatandaan nyo sa accounting subject nyo, meron tayong tinatawag na substance over form. Okay? So, mas masusunod pa rin yung substance over the formality. Parang ganun din dito sa contract. Wherein kung ano talaga yung napag-usapan, kung ano talaga yung napagmitan ng minds natin, yun yung masusunod. Okay? So, number 3, the non-conformity, yung kung bakit hindi nag-conform yung written instrument sa totoong intention is due to fraud, mistake, or inequitable conduct or accident. So, yun yung mga pwedeng maging reason kung bakit hindi nag-conform. So, by the way, nabanggit din natin last time na yung, for example, yung mistake in fraud ay one of the vices of consent. At kapag merong presence ng vices of consent, anong nangyayari sa kontrata? Nagiging voidable contract po siya. Pero, anong pagkakaiba nito sa isang contract na masasubject to reformation at sa isang contract na magiging voidable, which is ultimately subject to annulment. Ano pong pagkakaiba nun? So, tignan natin in the next slide. Okay. So, kapag ang pinag-uusapan natin ay reformation of contract, yung mistake, fraud, or inequitable conduct, nangyayari siya dito sa gitna. Okay, so tingnan natin yung first natin dito, yung first illustration natin dito. So nakikita nyo dito, consent of parties. So yung consent, wala tayong problema sa pag-a-acquire ng consent. Nagkakaroon tayo ng proper meeting of minds and eventually magkakaroon tayo ng perfected contract. However, okay, yung perfected contract natin, hindi siya nagko-conform with the written instrument. So, hindi siya parehas dito. So, dito nagkakaroon ng mistake, fraud, or inequitable conduct. Dito nagkakaroon, okay? Kaya may X tayo dito, okay? So, dito nagkakaroon ng mistake and fraud. Kaya hindi nagtutugma tong perfected contract na napag-usapan at yung written instrument. So, ang tamang remedy dito ay reformation of instrument. Okay? So next, ito naman yung kung saan nagkakaroon ng voidable contracts. Okay? So umpisa pa lang. So ang tamang remedy dito ay annulment. So pagdating natin ng voidable contracts, in detail, i-discuss natin itong mga to, itong annulment, ano ba ang effect ng annulment ng isang contract. Okay. So nagkakaroon ng fraud, mistake, or inequitable conduct dito pa lang. Okay? Dito pa lang sa consent ng parties. Okay? So, although magkakaroon tayo ng perfected contract, yun nga lang, merong defect yung consent natin. Okay? Kasi nagkakaroon dito. Dito yung timing ng fraud, mistake, fraud, and inequitable conduct dito. Okay? So, it doesn't matter na dito kung nagkakaroon pa man ba dito kasi ang ng voidable contract, okay? Ang parang kumbaga tinitignan natin is dito na timing, yung sa pag-a-acquire pa lang ng consent, okay? Or yung pag-meet pa lang ng minds, okay? So, although nagkakaroon ng meeting of minds, pero may defect yung meeting of minds, okay? So, ano yung mga defect na yun, okay? Pag-aaralan natin yan pagdating ng voidable contracts na chapter, okay? So, yan po ang pagkakaiba ng mistake, fraud, and inequitable conduct in reformation of contracts versus mistake, fraud, and inequitable conduct sa isang voidable contract. Okay? So, ayan. So, illustration tayo para mas maintindihan natin. Okay? Kung ano ba itong reformation of contract. So, S sold to be a lot with 10 hectare area. Okay? However, through mistake of the clerk, yung nagta-type nung nung kasulatan, okay? Their deed of sale showed, okay, dapat showed, okay, their deed of sale showed 1 hectare area only, okay. So ang nangyari, yung totoong napag-usapan na 10 hectare area, hindi siya nag-conform with the the written instrument, okay. So yung sinabi kong concept kanina, substance over form tayo, ibig sabihin masusunod pa rin kung ano yung real intention ng parties. So, pero syempre, pangit naman kung yung mismong deed of sale natin iba yung itsura. Kaya ang proper remedy dito ay ipa-reform natin yung contract. Kasi may possibility na nung na-type na ni clerk, hindi na napansin ni SNB na mali pala yung nakasulat na hindi 10 hectares kundi 1 hectare lamang. Okay? So may possibility na ganun. Okay? So itong example natin ito, nagkakaroon tayo dito ng mutual mistake. Okay? Resulting from the mistake of a third person. Okay? So kaya binanggit natin yung both Article 1361 and 1364 dahil pwede siyang mag-apply dito sa specific illustration na ito. Okay? So inuulit ko in this this contract is perfectly valid. Okay? However, ang merong defect, syempre hindi yung contract. Ang merong defect yung written instrument natin that represents the contract. So inuulit ko, ang nire-reform po natin is yung written instrument, hindi po yung mismong contract. Okay? So ayan, pag pina-reform natin yan, gagawa ng bagong deed of sale which will represent the true intention na this time. Instead of 1 hectare, magiging 10 hectare na. Okay? So another illustration tayo, pero this time hindi mutual yung naging mistake kundi ang reason ay fraud. Okay? So pwedeng maging fraud ang reason kung bakit hindi nagkakaroon ng tamang conformity yung written instrument to the true intentions of the parties. Okay, so for example, S sold to B a lot with 10 hectare. Okay, with 10 hectare area with a right of repurchase after 5 years. Okay, so meron daw siyang right of repurchase. Ibig sabihin, ibebenta muna ni S kay B yung lot na yan, yung land na yan, pero after 5 years, meron na siyang right to bilihin ulit from B. So, ayan, mababalik sa kanya yung lupa after 5 years pa pero. However, through fraud, okay, B made it appear that the deed of sale is an absolute sale. Pag sinabi nating absolute sale, ano yan, magiging pagmamay-ari ni B yung land na yan unconditionally, ibig sabihin, wala nang chance para mabalik yun kay S. Kasi pag absolute sale, magiging absolute owner si B. Okay, therefore, pag sinabi nating absolute sale, walang right of repurchase. Okay, so since the contract is in English language, S was not aware that the deed is different from their real agreement. So ayun nga, through fraud of B, okay, hindi nag-confirm, okay, yung deed of sale natin to the real intention of the parties. Okay, so in this case, in this reformation, okay, i-compare natin dun sa first illustration. In the first illustration, both S and B may ask for reformation. However, in this case, okay, ang pwedeng mag-ask ng reformation ay yung injured party. Siyempre, ang nag-fraud or, di ba, nag-employ ng fraud ay si B. So, hindi siya pwedeng mag-ask ng reformation. Ang pwedeng mag-ask ng reformation ay yung kabilang party in this case. Okay? Kasi hindi mutual eh. Hindi mutual yung fraud. Siyempre, hindi mo naman matatawag na fraud kapag naglokohan pareho, di ba? Okay, so ayan, usually ang definition ng fraud, pero yun yung definition pagdating sa pag-acquire ng consent, yung should have not been employed by both parties. Okay, pero saka na lang natin i-discuss yun. Okay, so ayan, inuulit ko, in this case, ang pwedeng mag-seek ng reformation is hindi si B, yung kabilang party. Okay, dahil si B, siya yung nag-employ ng fraud, kaya hindi siya pwedeng mag-seek ng reformation. Okay, so next example, next topic, so contracts that cannot be reformed. Okay, so may mga exemptions pa rin ang reformation. May mga certain contracts na hindi pwedeng ma-reform, such as number 1, simple donation inter vivos wherein no condition is imposed. Pag sinabi nating donation inter vivos, this is a donation made during the lifetime of a person. So pag nag-donate ako, that is what you call donation inter vivos. So ayan, paano naman kung hindi during the lifetime? Madodonate yun after death, okay? So, or upon death, okay? So, that's what we call donation mortis causa, okay? Pero, yung topic na yan, mas mapag-aaralan nyo yun pagdating ng, ng taxation sa estate tax, okay? So, ayan. Number 2, will, okay? So, will, last will and testament, mga ganon, okay? And number 3, when the real agreement is void, okay? So, yun nga, kasi kung hindi naman talaga nakabuo ng contract, wala tayong i-reform, di ba? So, parang kumbaga wala tayong magiging basis. Kasi, ang tinitingnan natin lagi is yung written instrument ba, tumutugma ba siya doon sa contract? Pero kung yung contract ay void, meaning wala tayong pagbebasean kasi non-existent yung contract. Okay? Wala tayong pagbebasean ng tamang, kumbaga, ng tamang, tawag dito, ng tamang kung ano man yung napag-usapan ng mga parties. Okay? So, ayan. Okay. When a person cannot ask or cannot seek reformation. Okay? So, nabanggit na actually natin yung isang time or isang situation or scenario wherein a person cannot seek reformation. Yung kanina, wherein ang example natin ay siya yung nag-employ ng fraud, si B, di ba, yung buyer, okay? Siya yung nag-employ ng fraud, so hindi pwede na siya yung mag-seek ng reformation in that case. Okay, pero in addition to that, may mga pwede pang persons na hindi makapag-ask ng or makapag-seek ng reformation. So, a party who enforces the instrument representing the contract cannot subsequently ask for its reformation. Okay? So, para mabigyan ng linaw, so meron tayong illustration, parang kahawig niya yung kanina. So, S unconditionally, pero this time, baliktad. S unconditionally sold to B a lot with 10 hectare area. However, through mistake, okay, the deed of sale appears to be a sale with a right of repurchase after 5 years. Okay. Both parties didn't notice the deed because they didn't bother reading it at all. Okay. So, ayan. In truth, okay, in substance, ito po ay isang absolute sale. However, their instrument reflects a sale with a right of repurchase after 5 years. Okay. So, if ever after 5 years, okay, si S, bigla niyang nabasa yung instrument. Meron pala akong right of repurchase dito ha. I-exercise ko nga, okay? So, tinatry niyang i-exercise, okay? So, ayun. Ine-enforce niya yung nakasulat doon sa written instrument. Pero in fact, wala yun talaga sa original na napagkasunduan natin, di ba? Okay, so yun ang nangyari. Okay? So in that case, from the time na in-enforce niya yung nakasulat sa contract, hindi niya na pwede, hindi na si S na nag-enforce ng contract, hindi pwedeng subsequently ipa-reform or mag-seek siya ng reformation ng contract. Okay, hindi niya pwedeng ipa-reform yun. Okay, so nakay binalang, okay, ang right to reformation. So inulit ko, from the time na, okay, originally, both sila, dahil ito naman ay mutual mistake, both sila pwedeng mag-seek ng reformation originally, pero nung si S, in-enforce niya yung nakasulat doon sa written instrument, from that time, okay, nawala na yung kanyang right to ask for the reformation of the contract. So, ibig sabihin, maiiwan na lang or tanging si B na lang ang pwedeng makapag-reform ng contract. Hindi pwedeng subsequently ipa-reform ni S yun. Okay? So, yun yung ibig sabihin nung binanggit natin kanina. Okay? So, yun yung mga times na hindi pwedeng mag-ask ng reformation yung mga parties sa isang contract. Okay? So, kanina, nabanggit din natin yung mga, di ba? Nabanggit natin na kung sino yung mga pwedeng mag-seek ng reformation. Pero in addition to those na mga nabanggit natin, sino pa ba yung pwedeng mag-seek ng reformation? Okay, kapag namatay yung mismong involved na party doon sa contract, syempre, bringing one of the characteristic of a contract which is relativity of contract, sabi doon, di ba? The contract takes effect upon the parties, their assigns, and their heirs. Okay, so ayan. Reformation may be ordered at the instance of either party. Okay, so generally yan. Or his successors in interest. Okay, if the mistake was mutual. Otherwise, upon petition of the injured party or its heirs and assigns. Okay, so kung makikita nyo dyan, besides from the parties actually involved in the contract, pwedeng yung kanilang successor in interest or yung heirs, di ba? Okay, so yan ang mga additional person na pwedeng mag-seek ng reformation in case na namatay yung isa dun sa mga parties or both parties namatay. Okay? Nandito na tayo sa interpretation of contract. So what is interpretation? Okay? Interpretation is the act of making intelligible that was not before understood, ambiguous, or not of use. Okay? So, usually, yung interpretation na ginagawa natin ay ini-interpret natin yung written instrument. Okay? Kasi, syempre, kapag nag-usap tayo with regards to the contract, so, magkakaroon siya ng, makukuha natin yung mga essential elements, yung COC, consent, object, and the cause. Siguro malinaw naman yun. Pero kung minsan, yun nga, hindi nagtutugma ang written instrument dun sa kung ano yung talagang naging intention natin. Okay? So, ayun. Tinitignan natin ano ba yung mga nakasulat na mga wordings dun sa contract, and then does it really reflect our contract? So, tinitignan natin, ini-interpret natin. Okay? Kung yun nga ba talaga. And eventually, kapag we found out that our written instrument is not in conformity with our real intentions, so pwede tayong magpa-reform ng contract. So that is based from our last discussion, di ba? Yung reformation of contracts. Okay? So, yung interpretation naman naman ay concerned doon sa mismong pag-a-analyze ng written instrument or 'di ba, pag-i-interpret ng written instrument, okay? So, in interpreting contract, the real intention of the parties always prevail over the written words. Okay, so that is based on Article 1370. So, the intention of the parties always prevail over the words that appear in the instrument of a contract. So, yun yun. Basahin nyo yung Article 1370, so yun yun. Okay, pero usually naman, kapag simpleng contract lang naman, hindi masyadong maraming rules. So, usually, yung written instrument, very literal kung ano man yung nakasulat, okay? Parang kumbaga, kung ano yung nakasulat doon, yun na yun, okay? And, in interpreting that contract, syempre, hindi na, ang kontrata naman kasi, kapag kino-construct siya straight to the point, hindi siya tulad ng mga literary works na wherein may mga figures of speech pa yan, na may mga deeper meaning pa yan. So, hindi ganun. Kapag nagda-draft tayo ng contract, dapat straightforward, straight to the point, and madaling maintindihan ng both parties. Okay? Pero, syempre, kung minsan, kung nagiging komplikado na yung kontrata, hindi na natin maiwasan na magkaroon ng several meanings or several interpretation yung mga mangilan-ngilang provision dun sa contract. Okay? Also, in judging the intention, okay, sabi nga natin kasi intention ng talagang titignan dyan. In judging the intention of the parties, okay, we will also look at the subsequent acts of the parties, okay, after the perfection of the contract. Titignan natin, ano bang ginagawa nila after ma-perfect yung contract, okay, so that will maybe, okay, that will maybe an indication na ganito dapat i-interpret yung contract, okay? So, pwede yun. Pwedeng natin pag-basean nung intention ng mga parties, okay? So, ayan. Punta tayo sa Article 1372. However general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those which the parties intended to agree. Okay, so para mas maintindihan natin tong provision na to, magbigay tayo ng example. Okay, so for example, si S nagbenta, S sold to be his house, including all. Okay, so nandyan yung nagpapa-general na term. So, Article 1372 is all about yung mga paggamit natin ng mga general terms, di ba? Okay, so in this case, yung paggamit natin ng word na all, okay, all furnitures, it generalizes, di ba? So, ganito, in interpreting this contract, hindi ibig sabihin na kung ano talaga yung mga makikita mo sa loob ng bahay na yun, na furniture, is automatically lahat ngayon, okay? Paano kung doon sa bahay mo, doon sa loob ng bahay mo, may mga furnitures doon na hindi mo naman pagmamay-ari, na hindi naman pagmamay-ari ni S. So, ibig sabihin, sa intention ni S, hindi naman talaga kasama yun, okay? So, pero syempre dapat nasabihan ni SCB tungkol sa bagay na yun na hindi kasama tong furniture na to kasi nahiram ko lang to, okay? So, in interpreting this written contract, yung word na all dito, it doesn't necessarily include all furnitures talaga. Syempre, hindi kasama dyan yung mga, yun nga, yung sinabi ko kanina, furnitures that are not really owned by S, okay? So, therefore, wala siyang right para matransfer yun kay B. Okay? So, that is Article 1372. Yung paggamit natin ng general terms, although general siya, hindi talaga siya general. Okay? Ibig sabihin, hindi natin pwedeng pilosopuhin na, hindi, yun yung nakasulat lahat, all. Okay? So, ibig sabihin, lahat ng makita ko sa loob ng bahay na yan, okay, sa akin na rin, parang ganun. So, hindi ganun yun. Okay? So, next, Article 1373. If some stipulation of a contract should admit of several meanings, it shall be understood as bearing that import which is adequate to render it effectual. Okay, so nagkaroon ng misunderstanding or let's say ambiguity dun sa contract with regards to let's say the object. Okay, so paano magiging valid yung contract na yun? Kasi yun nga, di ba? Kunwari, ang tinutukoy natin is object. Ano ba yung mga requisites ng isang valid object? Okay, so yun na-discuss na natin dun sa essential requisites ng Syempre, dapat legal siya, blah blah blah, marami pang iba, di ba? Okay, so At ito, example natin, okay? So, S sold to B his racehorse named Tom. Okay, pero incidentally, nagkaroon ng kalituhan kasi doon, marami siyang marami siyang racehorse and incidentally, napangalanan yung dalawang horses na Tom, okay? Pero, yung isang horse amputated or kulang ng paa. Okay? Syempre, kaya nga bumibili ng racehorse si B is pang race niya yan, malamang-lamang. Okay? So, hindi niya pwedeng pang race yung amputated na horse. Although may pangalan siyang Tom, okay? Para maging valid tong contract na to kasi hindi naman yun yung kumbaga hindi naman yun yung tinutukoy ni B yung hindi pwedeng makpang karera. Okay? So, ang tinutukoy dito sa sale na to, ang intention kasi ni B is pangkarera. Okay, so syempre, ang magiging object talaga natin doon is yung racehorse na may pangalang Tom na hindi pilay. Okay, so yun yung magiging interpretation natin dito sa contract na to. Although there are two horses with the name Tom. Okay, so yun yun. Next, Article 1374. The various stipulations of a contract shall be interpreted together. Okay, so lahat. Hindi ka pwedeng mag-assume nang nababasa mo pa lang ay portion ng contract. Hindi mo pwedeng sabihin ganito yung interpretation yan nang hindi pa nababasa together with the other parts of the contract. Okay? Attributing to the doubtful ones that sense which may result from all of them taken jointly. Okay? So, as an example para mas maintindihan nyo. Okay? Si X, pinaupa nyo yung bahay niya kay Y. So, nakasulat dun sa contract, X forbid Y from subleasing the property without his consent. So, bawal niyang isublease. Pag sinabi natin sublease, di ba pinaupa mo kay Y. So, si Y, ipapaupa niya ulit sa ibang tao. Okay? So, in this case, bawal daw. At further, it was also stipulated in the contract na if Y sublease the property to a third person, there will be an additional 100 per month payment on top of his rent. Okay. So, ganito, gawin nyo muna to. Try nyo nga munang basahin itong last, okay? Last sentence na ito. Pag binasa nyo itong last sentence na ito, anong maintindihan nyo? If Y sublease the property to a third person, there will be additional 1,000 per month payment on top of his rent. Pag yan lang ang binasa nyo at hindi nyo binasa yung other parts ng contract, ang maintindihan natin dyan ay pwede niyang isublease. Tama? Tama ba? Okay? So, pwede niyang isublease. Yun nga lang, magbabayad siya ng additional 1,000 per month. Pero, mali yun. Okay? Mali yun. Pag in-interpret natin siya as on its own, di ba? On its own, mali yung magiging interpretation natin. Okay? Ano nga dapat ang interpretation? Pag binasa kasi natin yung buong kontrata, in the first place pala, bawal kasi. Bawal isublease. So, this 1,000 pesos, okay, it's not additional payment actually. It's a form of, what do you call this? A penalty. Okay? It's a form of penalty. Okay? So, therefore, 1,000 pesos is a penalty. Hindi siya additional payment or hindi siya kasama dun sa wherein parang pricing plan nung nagpapalis, di ba? Na kapag ipapasublease mo, dapat merong patong pa, parang ganun. So, hindi ganun. Okay? This works as a penalty. Okay? So, ayan. Pag binasa nyo siya lahat, doon nyo lang maintindihan na yung 1,000 pala ay penalty. Pero pag binasa nyo lang yung mismong sentence na yan, akala nyo yung 1,000 additional payment kasi pwede niyang ipasublease. Okay, so, yun nga. Sa pag-interpret ng contract, kailangan nabasa mo yung buong contract. Okay, so next, Article 1375. Words which may have different signification shall be understood in that which is most in keeping with the nature and object of the contract. Okay, so, example tayo, R lease to E a roof for the purpose of erecting an advertising sign. So, gagawa siya siguro ng billboard or what, maliit na billboard. Okay? So, the contract provides for the termination of the lease if a building, okay, so building, yun yung specific word na ginamit doon sa contract, should be constructed on an adjoining property of such height as to obscure the view of its sign. Kasi, syempre, yun nga yung purpose niya nag-lease siya ng isang property kasi may papatayo siyang maliit na billboard on top of it. Okay? So, ayun. Yun nga, kapag ang nangyari daw is may nagpatayo ng building, okay? So, meron tayong quotation, building, tawag dito, ma-terminate yung contract of lease nila. Okay? Kasi yun nga, it will not serve the purpose of is objective, which is to yung mag-advertise nga, 'di ba? So ayan, there was erected on the roof of an adjoining building a sign which obstructed the view of east sign. So anong problema dito? Pag tinignan natin tong last sentence, actually hindi na nagpatayo ng bagong building, 'di ba? Hindi na nagpatayo ng bagong building, pero ang pinatayo ay ibang sign din. Okay, doon sa adjoining building. Okay? Ang pinatayo, sign, hindi building. Pero ang nakasulat dun sa kontrata natin ay building. Okay? Kapag nagpatayo ng building, okay, termination by the lease, if a building should be constructed on adjoining property. So, actually, this word building, it doesn't literally mean building talaga na, kaya nagamit to kasi usually building ang pinapatayo na katabi nung nung property na nilis niya. Okay, pero syempre ang purpose nun is to make sure na nasa-serve pa ba yung agenda ni E, which is to advertise kung ano man yung nakalagay doon sa pinatayo niya initially na sign, di ba? So kapag natakpan yun, malamang-lamang lugi siya doon, di ba? Nagbabayad siya ng lease, tapos yun nga lang yung objective niya ma-advertise kung ano yung nakasulat dun sa sign na yun. Kung hindi naman, wala naman nang nakakakita, nagbabayad siya, nalulugi siya. Okay, so in this case, this word building will also be construed to mean this one, yung sign na pinatayo. Although hindi building yung pinatayo, ibang sign din, at natakpan yung sign niya, so pwede pa rin yung maging ground for the termination of the lease. Although, literally, ang nakasulat yung building na word, okay? So, this building will also include this, the sign. Okay? Kasi, yun naman yung purpose kung bakit natin binanggit yung word na building. Kasi, actually, any other object na pwedeng makatakip doon sa sign na pinatayo ni E. So, yun ang magiging interpretation sa contract na ito. Okay? So, if ever ipapaterminate niya yung contract of lease, okay, meron siyang sapat na parang kumbaga ebidensya, or pag in-interpret tong contract na to in court, malamang-lamang mananalo siya. Okay? So, ayun, next tayo. Article 1376, the usage or custom of the place shall be borne in mind in the interpretation of ambiguities of a contract and shall fit the omissions of stipulations which are ordinarily established. Okay. So, as sold to be a horse, it was the customs of the place to place horseshoe on sold horses. Okay. So, even if the contract does not mention, okay, that the seller should put horseshoe on the horses that he is selling, kailangan niyang maglagay ng horseshoe kahit na wala sa kontrata kasi it is the customs of the place. Okay, so this is based on Article 1376. So inuulit ko, maglalagay pa rin siya ng horseshoe even if it is not mentioned in the written contract. Okay? So next, Article 1377, the interpretation of obscure words or stipulations in the contract shall not favor the party who caused the obscurity. Okay, so in interpreting the contract, so ayan, kapag may malabo, kapag i-interpret natin yun, hindi dapat doon, okay, hindi dapat in favor doon sa nag-cause ng obscurity na yan. So kapag si party A ang nag-draft ng contract at siya yung nag-cause ng obscurity, kapag i-interpret na yun, hindi dapat in favor sa kanya. Okay? Yung magiging magiging interpretation, okay? So next, punta tayo sa Article 1388 which is usually yung madalas lumalabas sa mga exams and tests, okay? So actually dalawang paragraph tong article na to, so 3078 paragraph 1, so this is the one, and next mamaya, okay? So when it is absolutely impossible to settle doubts, okay, so hindi talaga natin masettle kasi yun nga, malabo, okay, malabo yung kontrata, by the rules established in the preceding articles, and the doubts refer to incidental circumstances of a gratuitous contract. So we are dealing with a gratuitous contract. The least transmission of rights and interest shall prevail. If the contract is onerous, the doubt shall be settled in favor of the greatest reciprocity. Okay. Okay, so ayan. Nahiwalay natin yung example nung onerous contract. Okay. So, kapag gratuitous daw, okay, ang magiging interpretation natin is to the contract that has the least transmission of rights and interest. However, if we are dealing with onerous contract, so siguro malamang alam nyo ng pagkakaiba ng onerous and gratuitous contract. Pag gratuitous, ang cost is usually the liberality of the one for example in donation, okay, for the one donating, okay, the object, okay. However, in onerous, there is an exchange of valuable considerations, okay. So ayan, kapag onerous contract naman daw, isi-settle natin yun in favor of the contract with the greatest reciprocity of interest. Okay, so example tayo. So first example, we are dealing with a gratuitous contract. So it was not clear whether A lent or donated to B a specific phone. So is the contract a comodatum or a donation? Pag comodatum, pinahiram lang. Pag donation, binigay na. Okay, so ano ang magiging natin kung hindi malinaw kung ano talaga. So sabi dito, balikan natin, least transmission of right. So obviously, nagkakaroon ng least transmission of right kapag pinahiram mo lang, okay? So this contract will be interpreted as a contract of comodatum, okay? So yung naman, okay, so ito yung example natin. It was not clear whether A sold or leased to be a building. Is the contract a sale or a lease? So this time it is an onerous contract between a contract of sale and a contract of lease. Kapag binalikan natin yung Article 1378 paragraph 1, so sabi dito, the doubt shall be in favor of the greatest reciprocity of interest. So obviously, okay, saan nagkakaroon ng greater reciprocity of interest, okay, or exchange of interest? So that will be a contract of sale. So kabaliktaran naman siya sa gratuitous contract. Okay, yung gratuitous contract kasi least transmission of right, pero ang onerous contract yung greater reciprocity. So sale tayo in this case. Okay, so how about paragraph 2 ng Article 1378? If the doubts are cast upon the principal object of the contract in such a way that it cannot be known why or what may have been the intention or will of the parties, the contract shall be null and void. Okay, so ayun, malinaw. For example, yun nga, nagbenta ng lupa tapos hindi natin matukoy kung anong specific na lupa. Okay? Kahit nung tinanong na natin yung mga seller and buyer, hindi nila alam kung ano yung binenta at binili nung isa, di ba? So, malabo naman yun na ganun. Parang kumbaga, sabi niya, bentahan kita ng lupa. Okay, farmland for example, di ba? Tapos, sige, bilhin ko na. Okay, so nagkaroon na ng bayaran, nagkaroon na ng deed of sale, pero never pa nilang nakita yung specific na lupa. Si S nag-i-imagine na meron siyang lupa sa specific na area na to. Okay, pero hindi niya matukoy kung alin doon sa sobrang dami niyang lupa. Okay, so that will be a null and void contract. So kailangan nilang gumawa ng bagong kontrata para okay? So kapag null and void 'yun, ibig sabihin kung nakapagbayad na yung isa, kailangan niyang ibalik 'yun kasi that payment is not based upon any contract. Okay? So that is Article 1378 paragraph 2. Okay? So I believe that is the last, okay? Okay, so that is the last topic on the interpretation of contract. So, this is another short video. Pero, pagdating natin ng defective contracts, malamang marami tayong explain dyan. Okay, so coming up next will be the defective contracts.